moderating the chat throughout. Thank you very much. I'll pass you on to Sarah.
Thank you, Gemma, and good morning, good afternoon, everyone. So today we're looking at risk management. It's sort of roughly split into two. So we're going to look at kind of common causes of disputes from my experience of over 20 years, let's not go any beyond that, over 20 years of dealing with construction disputes. So we're going to look at the problems that you can have with the contract itself and also the project. And then the second half, we're going to look at avoiding and mitigating the potential risks. So things like project management, document management, negotiating, trying to resolve disputes, which, by the way, I'm hearing is, quite a difficult area at the moment. It seems that, some parties aren't keen to negotiate. So, hopefully some kind of helpful tips in terms of negotiating, but also it says here, preparing for a fight. And I do think the two work together. Effective negotiation and preparing for some form of dispute resolution actually do work really, really well together. So first half is going to be about 14 slides. So first of all, common causes of dispute. I mean, a lot of this can just be down to a sort of mixture of everybody trying to do things too quickly and or as a result of that, not really preparing. So, start on site too early. It's so common. Clients want the work started. Parties sign contracts that they haven't really reviewed very well, etc., causes all sorts of trouble. Letters of intent, we'll do a little bit on that. Buying work or experience, that's always tricky. We all want to get into different areas and have a variety of experience. But sometimes, that can cause problem. Because, if you're buying it of necessity, you're probably not charging what others would be charging for it. But also because you don't have the experience, you've got to acknowledge that it's not going to be a particularly profitable project. And what often happens is that parties do this and then, 12, 18 months down the line, when they're looking at the account, they forget that, there were other reasons why they wanted the work. They're looking at the bottom line and wondering why it's not being very profitable and, looking for claims. The lowest price, is often problematic, and also either a misunderstanding as to the scope of work or a scope of work that is unclear. I would say that disputes about the scope of work, so when we're on NEC, the works information are probably 60% of the disputes that I do. Surprises, now, when I say surprises, again, it's not knowing the risks, because, and it goes back to the initial point that I've made, quite often everyone's too keen just to get going and move on with the project. And those risks, common ones, ground conditions and third parties, so statutory undertakers. Other causes of dispute, late notification of claims, that's really key. I think every adjudication that I've had through the last 2 years of the pandemic, that has been an issue that has been raised. It rarely succeeds, but get your claims in on time. Cash flow problems, bad bargain. And again, it all comes back to this, not preparing sufficiently at the outset. So high liquidated damages, we're going to look at that. Ground conditions, often a problem. Misunderstanding as to the scope. The contract not incorporating contractors or subcontractors' caveats and exclusions. So, several instances where contractors, subcontractors tender is submitted with certain caveats, exclusions, quite often that they won't take, the risk of any, unforeseen ground conditions, for example, but then that doesn't find its way into the contract. So all those lovely caveats and exclusions that have been prepared for the tender are just a waste of time because they don't find their way into the contract documents. Or they do, but there's a hierarchy stated in the contract, a hierarchy of documents, and the list of caveats and exclusions is right at the bottom and is superseded by something elsewhere that says they are responsible for ground conditions, etc. Lack of collaboration. That can cause all sorts of problems, but I would say that all of the claims that I've had with regard to defects, so that can be a design defect, workmanship defect, I would say that an element of the problem for such claims has always been an element of, lack of collaboration. Quite often, designer sends the design to main contractor sends it to subcontractor. It's all done by email. Something gets lost in translation somewhere, and we end up with a gap or an error as to the design, and unfortunately defects. So if we just drill down to some of these issues, so liquidated damages, there's been a lot of case law on liquidated damages. So the old test, well, if we go back to basics, liquidated damages typically are used in construction with regard to delay. They can be used for other things. If we go back to our basics of contract law, if you have a completion date of 30th of April in the contract, contractor is to complete by that date. If contractor fails to complete by that date, it's a basic, simple breach of contract. And client employer is entitled to damages in relation to that breach. Liquidated damages is simply saying we're going to fix a figure, an amount that is payable in that event. So it's not limited to delay. So you could have it for performance, but we don't tend to see that in the civil engineering contracts. Usually it's limited to delay for us. So the first thing with liquidated damages, because you're fixing a figure and it's in the contract, the rule is that it's got to be a genuine pre-estimate of loss. So you're estimating, and usually, of course, it's the client who's estimating, they're estimating what loss they might suffer in, 12 months' time if the contractor doesn't complete on time. If it isn't a genuine pre-estimate of loss, if it's a penalty, so, £1 million a week, generally speaking, would be a penalty because it's just way more than, the loss that anyone would suffer, then the court will effectively strike it out and you revert back to general damages where party wanting to be paid their losses, so the client would have to substantiate and detail what loss they've suffered. Now, recently the case law, and it's a case called Cavendish and McDessie, it's 2015 case, it widened this genuine pre-estimate loss so that it was widened to help employers, so it doesn't help contractors. So basically, you are less likely as a contractor to be able to show that liquidated damages are a penalty. So when you're negotiating your contract, second bullet point down, when the liquidated damages are put into the contract, you should ask for a breakdown of, you know, what anticipated losses they are, because it's going to now be quite difficult in a dispute, once the contract's been signed, to challenge the amount of liquidated damages in the contract. Third bullet point down, be careful, contractors, even more so, because what we're seeing are clauses that say, you know, this is the liquidated damages, and we all agree it is not a penalty. So if you sign up to that, you are even less likely to be able to challenge it if it goes to dispute. And at that point, you suddenly think, goodness, these liquidated damages are way too high. It's just making it less and less easy for contractors to challenge what the contract actually says. So if the court says that the clause is a penalty, then you go back to general damages. It doesn't get the contractor off the hook for paying anything. Now, just a word about, so this is this final bullet point, what you put in. So your liquidated damages are always in the bit of the contract that you fill in. So contract data part 1 in NEC, employers requirements, contractors, no, it's not, the contract particulars in the JCT form of contract. So it has to be filled in, because obviously it's different for each project. So just be careful here. If by, you know, how much liquidated damages are going to be charged, it says nil or 0 or nothing, then that's good for the contractor, because that looks like it doesn't matter how late you are, the liquidated damages are nil. Whereas the final line, if it says, for example, NA by the liquidated damages clause, that means not applicable. So what it's saying there is how much liquidated damages will be charged, not applicable. So it's saying that clause isn't applicable, and generally speaking, liquidated damages will be payable by the contractor instead. Now, it all depends on exactly how that question, you know, how much liquidated damages are payable, is pitched in the contract, but that's the general rule of law. If you have definitely agreed that no liquidated and no general damages are payable, you know, my advice is get it put clearly into the contract. Don't be putting these wording in, you know, get something really, really clear in, you know, no general damage, no liquidated damages, you know, the contractor is not liable for any delay, albeit, of course, that's going to be really, really rare. Quickly, collateral warranties. There's no magic to collateral warranties. It's basically, at law, we have a principle that is privity of contract. So contractor and employer contract with each other. Third parties can't bring claims for example, defects, even if they have subsequently purchased the building that the contractor has built. So the way around this is contractor is required in its contract with the employer to give a collateral warranty to future purchasers, which means that future purchasers, tenants, funders, for example, can pursue the contractor if, for example, there are any defects. Obviously, it doesn't mean that contractor can end up paying for the same defects several times. It's only the party who has suffered the loss who can make the claim. Now, just a tip here, quite often contractors, subcontractors, professional indemnity insurers have kind of key points that, you know, they will use and that the contractor or subcontractor can use to get better terms on the collateral warranties. So do use any points that your PI insurers have to assist in negotiating your collateral warranties. So if you're somebody who likes a pro forma, I I'm not. Well, I do, but I don't like filling them in. But I think a kind of pre-contract review pro forma is really helpful. It's helpful in negotiating the contract. It's helpful in reporting up and down your chain internally. But it's also, and we'll see this later, I think helpful when you have the handover from the tender team have won the project and potentially negotiated the contract, and that's all signed, and then they're handing over the project to the site team who are going to build. If you've got these issues and bullet points in a pro forma, I would have said it's going to be a lot easier for various people to just pick that up and see, what the contract is about. So these are a list, quite a long list of the key issues from my perspective. You may have others and you can add to it. The one right at the end, the specification exclamation mark, you might want to add things to that. For example, ground condition reports, who's responsible for ground conditions. So, some of them quite obvious, who are the parties to the contract, so you've got a kind of checklist when you're signing the contract. Are you signing up to, is the employer the right party? Critically, is it the party that has the money to pay for the project rather than a related company that doesn't? Another one, design responsibility. Do you as a contractor have design responsibility or not? Standard of care. If you have design, it should be reasonable skill and care, not fitness for purpose. Limitation of liability, we're going to talk about that a bit later on. Conditions precedent, we're going to talk about that later on. We've talked about liquidated damages. Completion date, that's going to be really important to everyone, but particularly the site team. Blockers for payment, so late delivery of any bonds that are required, collateral warranties, programme, they're all issues in the NEC that can delay or hinder payment, termination provisions, and of course finally the specification. So bear that in mind and all the issues covered there, because we're going to come back to that later on. Key issues post-contract. So we're looking still here at protecting yourself, pre-contract and immediately post-contract. So, as you're starting on site, is the contract agreed? Has it been signed or executed, whichever one it's going to be? If not, on what basis are you starting work? Are you going to get paid for it? Which, you'll probably have guessed leads us on to letters of intent, which we'll look at in a minute or two in more detail. If you're on a letter of intent, that's fine, but what are the limitations to it? And also, don't forget to keep that focus on getting the contract itself finalised. Don't get to the point, as I've seen several times, where the work's been completed and the contract still hasn't been finalised, or the parties have forgotten about it and the work's all been done on a letter of intent. And also, as I've already mentioned, ensure that the relevant people are familiar with the relevant provisions in the contract, which is where that pro forma might come in handy. Next thing. So this is sort of, probably at handover stage. So you've got hopefully your pro forma that we've just looked at, that's all been signed off, contracts signed, possibly you're on a letter of intent and you're looking at handing over to the operators, the people who are going to be on site carrying out the work. Your pro forma can help this. So people on site, they need to be diarising the key dates. So they're things like, applications for payment, when you're going to be paid, when employers or the paying party, if you're on a subcontract, when their notices are going to be issued, what conditions precedent there are, so key time limits for notices, the procedures for variations, extensions of time, etc., the technical risks on the project. So I can't really say much more about that. That will be something that you will be familiar with, having looked hopefully through the scope in some detail. And then, of course, at the end, using the contract pro forma as the handover. So coming back to letters of intent, just want to look at that in a little bit of detail, because generally we have two forms of letter of intent, the non-binding form and the binding. They are what they say they are on the tin, effectively. A non-binding, you are going to have real problems with this because it's not binding. Usually you are not going to be entitled to any payment, and you are not going to be able to adjudicate under a non-binding letter of intent. So how can you recognise it? Usually it's clear on the face of it that it's an agreement to agree something in the future. So typically it will be quite short because it's not looking at any kind of terms and conditions. But also, where I say it's clear that it's an agreement to agree, it will typically say something like, we're looking forward to working with you on this project. What we are going to do now is to try and agree the agreement that we're all going to sign up to. But in the meantime, we'd like you to do some work. That is saying there is no agreement until we have signed this agreement that we're looking at in the future. So really be careful about that. Another one that's a kind of indicator that it's this non-binding letter of intent is because it says it's subject to contract, which basically means there's no contract until the written contract has been signed, sealed and delivered. And usually it won't contain any commitment to pay, which is why I say it hasn't got any real terms and conditions. It's all very one-sided. Contractor's going to do A, B, C, D, E. Thanks very much. And we'll try and get the agreement signed and sorted out in the next few weeks, few months or whatever. It's not adjudicatable because it isn't a contract. And it's not even a non-written, a verbal contract. So that causes problems in itself. If you have a dispute, you're going to court. And the basis of your claim at court, you'd have a contract claim. So you're on a quantum merit basis, which is basically a kind of equitable basis. It's sort of fair. There's no contractual entitlement to something, but the courts would say, well, if you've done work, providing it's not been for on a charitable basis, then you should get paid on a quantum merit basis. So none of that is great for contractors or subcontractors. Binding letter of intent, there are terms and conditions contained in it. Usually it's quite a long letter. It basically makes it clear that contractor or subcontractor is going to get paid. So the 4 Ps are the parties, the price, the project. So, the extent of the project and performance. So extent of project, basically scope. Performance is the standard of performance. They're all contained in the letter of intent. Such a letter of intent you can take to adjudication if there's a dispute over it. But bear in mind the third bullet point, they're very, very limited. And what you will often find is that they're limited because, if you look at the second bullet point, they don't contain anything limiting the contractor's liability. Sometimes they don't state what the standard of care is. So the automatic standard of care then for design is going to be fitness for purpose, and they might not be particularly clear as to when you're going to get paid. So generally speaking, a letter of intent is more helpful to an employer than a contractor. So, be really careful, review them before you sign up to them, and don't be afraid to go and get them amended before you sign up to include those key clauses that might have been missed. Also, beware of any limitations to the letter of intent, which usually would impact on the contractor. So this final bullet point. Quite often, they're limited as to payment. So they might say, you can do work up to £50,000. If you do work beyond that, it's outside of the letter of intent. Ditto limiting the scope, so ground investigations only. If you do anything more than that, it's outside of the scope. And also timescales, you can do work within the next 2 calendar months. So if you go beyond that, it's outside the scope. You get the drift. So just be careful about those points. Just a quick word about conditions precedent. So these are all about timescales in which to, excuse me, submit notices. So you might think, oh, well, that's not really very important because it probably has no effect on the work that we would do. But actually, I'm afraid in quite a lot of situations, it is important. Excuse me. So basically, again, we go back to the fundamentals of contract law. If you have to submit a notice within, say, 2 weeks of becoming aware of an issue, if you fail to do that, then it's on a basic level, breach of contract. You haven't complied with the contract, and you have to pay any losses to the other party that result from that breach. Now, usually there aren't going to be huge amounts of losses from a breach where all you have not done is failed to submit a notice. Condition precedent is quite different because what it says is the consequence of you not submitting the notice within the time scale. Sometimes the word condition precedent is in there, sometimes it isn't. So the wording would be something like contractor must submit a notice within 3 weeks of discovering something. And if it fails to issue that notice, it won't be entitled to any extension of time or money in relation to that issue. So that's the condition precedent, the bit that says if the contractor or whoever fails to issue the notice within the deadline, it will not be entitled to any money or any time relating to the issue. So it's a clause where it tells you you've got to submit a notice, but what the penalty is for not submitting that notice. We're seeing these a lot in construction contracts. The court will enforce them, so we need to comply with them. So this second main bullet point for contractors and subcontractors, what you need to look out for is where you notifying a variation, an extension of time, loss and it's not L&D, it's L&E, loss and expense. So that's JCT. For NEC, it's a compensation event. For next bullet point down, the key one for employers is the payment notices and payment provisions. If they don't submit a notice, they could find that they've got to pay the sum that the contractor or subcontractor has applied for in its application for payment. So hopefully you can see there why that they're so important. Just going back to other items to protect yourself in your contract, limitation of liability. We looked at that in the context of the pro forma when you're negotiating your contract, but also your letter of intent. If you want a limitation of liability, make sure you get it in your letter of intent, otherwise it doesn't apply. And also it means if it's not in your letter of intent, it's then really difficult to negotiate it into the contract, because the employers allowed you to start work on the basis of the letter of intent, and psychologically it's going to be difficult for them to accept any kind of limitation of liability. So the first thing to bear in mind is that the clause must be reasonable and clearly drafted, which might seem really unfair because it's probably the only clause that the contractor will want, will really need inserting into the contract, which the employer hasn't already dealt with. But if it's not clearly drafted and reasonable, then it won't be enforceable. I'm sorry, that's just the law. Several ways to limit your liability. You can do it, you can use all of them or just some of them. So you can limit the time. Usually you're liable for 6 to 12 years, depending on whether the contract's a deed, 12-year liability, or a simple contract, so just signed, in which case it's 6 years. So that's a long time to be liable, so you might want to reduce those timescales. Second way is in monetary terms, so quite often we see a cap. Quite often it's no greater liability than the contract sum. You might even want it less than that. And also you might want to limit consequential losses, but you would need to define those. Critically, do they include loss of profit? And I would say if you're the contractor or a subcontractor in a subcontract, you do, if you're limiting them, so you're saying, you're not liable for them, then you do want to include loss of profit. So you should specifically state that, because typically consequential losses will not include loss of profit. In fact, consequential losses undefined will include very little. So on its own, it's not particularly helpful clause unless it includes loss of profit. So moving on to agreements. So this is quite wide because agreements cover your letter of intent. They also cover the contract that you enter into after the letter of intent, or just generally the contract that is signed. But of course, it also includes any form of agreement that you reach through the works being carried out. So it could be agreements as to the value of variations, the extent of an extension of time, or it could be a settlement agreement at the end of the project. So bear that in mind. All of them are really important. All of them, and particularly as to whether or not it exists, has an agreement being reached, is a real source of dispute between the parties for those last few items. So agreements about things through the project and the final account. Quite often one party will think agreement has been reached, the other party will say no, we haven't reached an agreement. So bear in mind with all of these that we need an agreement, and the first principles for agreement, first bullet point, we need offer and acceptance. So one party has offered something, the other has accepted it. So if your acceptance is, well, yes, we agree all of that, but payments within 7 days, for example, you need to get confirmation, you need to get the other party to agree that, because the but bit, the but payments in 7 days, the extra, the add-on, or the bit that you change even slightly needs to be accepted by the other party, or there is no agreement. Clarity is really important as well. It should be in writing or confirmed in writing. So, have verbal discussions, but immediately confirm it in writing. I like, if you're agreeing it verbally, I like once you've kind of had the toing and froing of the agreement, is payment 7 days or 14, does it include retention? But, at the end of the discussion, go through the key points of the agreement. Before you end the call or the meeting, just to make sure that everybody's thought things through, so you don't then end up sending the confirmation email or the confirmation note, and the other side or the other party comes back and says, no, that's not what we agreed. Yep, so penultimate bullet point, instructions and variations, formalise, anything that's said, put it in writing, even if you didn't say it, particularly with instructions or variations, contractors and subcontractors on subcontracts. It's in your interest to formalise it, to record it, before you actually start work on it. And note, if you are varying your contract, so not agreeing a final account or something like that, but if you've agreed that instead of having to notify a change or notify something, you're agreeing that actually we don't need to do that, it's too much trouble, it's not helpful. Amendments to contracts like that, usually they need to be made in writing, and quite often there are other formalities. So if you're going to genuinely change the contract, you should check that you do that properly and probably take legal advice. For example, if your contract is a deed, any amendment needs to be made as a deed. So next, measures to protect yourself, recording agreements. So, this can be done as an agreement or as a contract, but sometimes it might just be done as correspondence, letters, emails, texts, not great, but, it's still a record in writing, pro formas. The key here, and this applies to whether you're recording an agreement or you're just recording a discussion. It might not necessarily be, a binding agreement, a settlement agreement of one form or the other. It could just be a discussion. The key thing is that anything that is discussed should be put down in writing, number one, and the written document should be shared with the other party to give them the opportunity to say, nope, that's not what we discussed. And this is why internal notes in this first bullet point is right down at the bottom of those sub-bullet points, because any diary entry, internal document, the other party hasn't been given the chance to say, oh, no, you misunderstood that. That's not what we discussed. That's not what was agreed. So this, these sub-bullet points are all items that are really, really good ways of recording information, recording what's happening on a project, particularly programs and photographs, important as to the timing of things, if you're going to be needing an extension of time, if there are any delays. Minutes of meeting, critical, because of course a meeting itself, it's all verbal and different people will come away with different views as to what was discussed and what was agreed. So kind of moving on to records generally, records are absolutely key for all sorts of things. The issue about them is that you might think you're not going to have challenges and issues. You might not, you might think you're not going to have any delays, you're not going to have any claims. But if you don't keep records, it just means that it's going to be really, really difficult to substantiate any claims, at a later date. So records And these are good records. So it's not, just, odd words jotted down on a diary. We're looking at, the records that we saw in the previous slide, minutes of meeting, emails, correspondence, etc. They show entitlement. So we're looking, for example, at notices that you've got to issue, and bear in mind some might be conditions precedent, entitlement to instructions, to variations, to extra time. Also, records are important as to quantum as well. So proof of cost, proof that you've paid your subcontractors, your suppliers, etc. Obviously, if you've got good documentary records, you're not then going to be having to rely on verbal evidence, which typically, can be unreliable. So who of us can remember, for example, what we were doing 3 months ago? Who can remember what they were doing 2 weeks ago, never mind 3 months ago? And then, if you think, well, what kind of detail are we going to need? Well, who was working on a particular compensation event? Over what period of time were they working on it? What were they doing? No one can remember that. So, this is why records are so important. And, final bullet point here, be consistent. If you've got pro formas, it just makes this information easier to put down in writing, because you've already got the form to complete. And if it's completed properly, then and the pro forma is, a good pro forma, somebody is giving the information that's needed. Just a quick one there. Don't need to. We've already covered that, but yes. Just keep you calm with all your documentation. Always think about the fact that the documentation might be shown to a third party at some point in the future. So be careful of your language. Some people would say, keep out all emotion. I don't mind a bit of emotion. Not sweary emotion, but, a bit of frustration, because, quite often there is genuine frustration, but keep it professional. Minutes of meeting. I just want a quick word on this. We've already seen they should always be prepared. Otherwise, they're pretty pointless in terms of, a record as to what has happened. You're going to then be wholly reliant on people's recollection, and I can pretty much guarantee no one will remember what was said or discussed at a meeting in any huge detail. So make sure they're prepared, make sure they're circulated so that everybody gets to see them, so everyone gets the chance to approve them, or say, no, actually that doesn't meet with my recollection. But also, if you're the party who is sent the minutes of meetings, so they're prepared by a third party, please check them. It's really tedious. I hate checking minutes of meeting, but it's really critical. We had a whole adjudication and it's centered around an agreement in some minutes of meeting. And my client said that it was incorrect. That point hadn't been agreed. Now, fortunately, we found a letter that was sent subsequently, not querying those minutes of meeting. I don't think the client had actually even read the minutes of meeting, but it caused us huge problems. We did have something in the end, but not a nice place to be. Okay, so want to look first here at disputes that might arise, because this is all in the context of negotiating. And I think you need, when you're starting to get into negotiations, you need to know where you might be going with it in order to prepare your negotiations, in order to settle. And this is where I said, at the start, very often the dispute resolution method and the negotiations go hand in hand for lots of reasons, which will hopefully become apparent. But one of the reasons is psychologically, if you are always proceeding on the basis that you will settle, then I think you almost hamper yourself, because psychologically you know that whatever is offered must be accepted. And sometimes that is the basis upon which you are proceeding. You know you're not going to dispute resolution, but not always. So don't always tie yourself into just settling. So disputes that might arise and how you might deal with them. So adjudication, typically, that is it. Sorry, there's a typo there. It should say merits or smash and grab. Two forms of adjudication generally. One is on the merits. Usually we're looking at a final account dispute, or something cherry picked from a final account. So you might have a big variation that's worth quite a lot of money. So you might adjudicate that because it would be quick and easy, and then leave other claims till later on, or hope to negotiate them. So where I talk about merits, it basically means that you have to prove your claim, as opposed to a smash and grab, which is usually under the Construction Act. So client, paying party, employer hasn't issued the payment notices that it should have done. And at that point, what is deemed to have been agreed as the sum payable is the sum in the contractor or the subcontractor's application for payment. If that's not paid, then you go into a smash and grab adjudication, which is basically proving that the notices haven't been served, an entitlement therefore to payment under the Construction Act. So that's smash and grab is a fairly quick and easy adjudication. Similarly, if you remember the deeming provisions in NEC about quotes and the quotation provisions, they would be a similar, they're all about notices, so they would be similar to a smash and grab, as opposed to merits, where you've got to show, number one, it is a compensation event. It's one of the compensation events. Number two, that the quantum attached to it, is the right amount. Here are the invoices, here's the substantiation. Number three, that any time attached to it is the right amount of time. It's all in the critical path, etc. Court proceedings or arbitration, usually in construction, that's where we take defects claims. So for contractors and subcontractors, you would be typically the defending party in those claims. Mediation, usually that would be rather than making a defects claim, you could have mediation instead of adjudication for a final account claim, but it's rare. The parties seem to prefer to go to adjudication and stroke or negotiate between themselves first, although I must say I'm finding that negotiation between the parties, is very much getting sidelined, and parties are either choosing or being forced to just adjudicate a final account. Pre-action protocol, we're going to look at that in a minute, but basically the first stage to that is a fairly detailed letter setting out the claim. I think that's quite a good thing to do tactically, and we'll have a look at that in more detail. You need to assess what type of claim you have before you can decide on your strategy, in my view. And also don't forget that if you've got any form of admission that sums are due, then the reality is there's no dispute, and you could take the matter to winding up proceedings to get a quick payment. So in terms of the merits of adjudication, as I've said already, it's usually the final account dispute, or you can cherry pick, certain claims. So, for example, a large variation, an easy extension of time claim. Also, if you are the employer or the contractor in a subcontract, you might want to adjudicate, and this final bullet point is a preemptive defensive adjudication to get declarations to basically keep control of the project. Smash and grab, we've been through that. So in terms of negotiating, it's always important to have a strategy in negotiation, which is why I think you always need to know where you might be going, adjudication, court proceedings, etc. If you don't resolve matters, you may have no intention of going there. You may have every intention of resolving. But if you're constantly talking about resolving it, you might end up giving the impression that, that is all you're going to do. And at that point, the other party is just going to stop negotiating with you, because if they know you're not going to adjudicate, then what is the point of negotiating? So work out what the dispute is about before you think about your strategy. So, for example, here you might miss a smash and grab opportunity if you start going into the merits straight away. Also, you might forget about some of the kind of key boxes that you've got to tick in order to succeed in such a claim. So, for example, parties quite commonly, particularly a claiming party, forgets to think about causation. It's very much, right, well, we've got this compensation event, unforeseen ground conditions. It cost us X amount of money. We need X weeks extra time, but it doesn't deal with causation, to actually prove that the problem with the ground conditions actually caused that extra time, caused that additional money. So, this is why it's important to look at these things. It's also important to review the strategy fairly regularly, because it's a fluid thing. It might not stay the same. I always think it's good to consider sharing timescales. You may say, well, we'd like to resolve things, so we're going to put aside this next month to negotiate with you. But once the month has expired, then we are going to, have to consider or refer this matter to court or adjudication or whichever one. Without that last bit, you haven't really got a strategy, and the other party doesn't really know where you're going with this, except potentially unlimited negotiations. And finally, of course, we already know this: record any settlements and agreements that you get in writing as you go along. So what might your strategy cover? Well, first of all, are you going to set out your claim formally? I always think this is a good idea. It shows, first of all, it makes you, as the claiming party, focus on, the pros and cons of your claim. It also, hopefully, will make the other side realise that you're serious about the claim. You need to refer to the contract mechanisms to escalate the dispute. Sometimes there are director discussions, so think about those, but don't waste that opportunity. If you're going to go for that, make sure that both directors have a nice pack that they can refer to, so they know exactly what the claim is about. Use your project documentation where it helps. We've seen a lot today about minutes of meeting, emails, programs. Where they help you, use them to support your claim. Don't leave them until you're in adjudication. If you've got this information, show off, use it. supply it. Don't just refer to it, really show off with it. Here's this email where, you said X or we said Y. Really, really use it to help you. Think about who you're going to negotiate and liaise with. Do you need to escalate it up to director level? Get it out of, get it away from the people who have, dealt with it for months and possibly years, and have some emotion tied into it, whereas the directors might be more interested in doing a deal, getting it out of the way, moving on to their next project. They might have all sorts of operational reasons why they want to do a deal, whereas the people who you've been dealing with on a site level possibly don't have any visibility of that. Subcontractors, is there any chance of approaching the employer direct to get some assistance with the negotiations? Think about who within the organisations who might be able to assist you and get some traction in negotiations. Think about the tactics, think about your opponent, the other party, and what they're looking for. What might persuade them to negotiate? Is it going to the director? Is it going to someone who personally within that organisation and saying, can they, influence and try and get some negotiations? Is it talking about, well, what work we can do in the future if we can get a resolution here, about preserving relationships? Also, get information from your third parties. So your subcontractors, we talked about, quantifying the claim. If you're going to do that, you'll need that quantum information from your subcontractors. And also bear in mind that some firms are just more litigious, they're more dispute orientated than others. So in the context of that, you might want to consider sending a letter of claim. As I've said, this could be badged as a pre-action protocol. I like to do these because I think it's a good sense check of your own case, but also it's quite good to have something that sets out the detail of the claim to send to the other party to get them to see that you are serious about this. So these are kind of probably, paragraphs in the letter of claim. So the first one could start, the purpose of this letter is to set out the claim because, it's a substantial amount of money. We need the extra time and relief from liquidated damages, etc., etc. Next paragraph, the nature of the claim is that, we need payment for variations, we need extra time, etc. The next one, the history of the claim is, and then, this is your opportunity, what happened on site, we were told to do this extra work, it's a variation, etc. This is your opportunity to show off and, enclose, your documentation, your minutes of meeting that show X. Don't just chuck it all in. Be selective. Next point, relevant contract provisions. What contract clauses are you relying on? You may know what the clauses that the other side are relying on. So again, refer to them and explain why they're not relevant or your clauses are more relevant. Next paragraph, notification requirements. If you're required under the contract to notify, and you have, again, show off. The contract requires us to notify, and we have, we notified you on these days, we've attached them. Or it might be, if you're defending a claim, you were required to notify us, you haven't, and therefore you have no entitlement. Why we say you're liable, and then continue, how is your quantum and your delay calculated? Again, substantiate it, provide the documentation. Don't just throw it all in, refer to documents selectively. Next point, what do you want the other side to do? Obviously, you want them to pay or to give the extra time, extra money, but you might want to give alternatives. So, pay in full or give them the opportunity to meet to try and reach a settlement. Set some timescales, though. Don't leave it open-ended. Also, really good to refer to the dispute resolution clauses. It's good because, it's a reminder to you as to what they say. They might have some helpful provisions, for example, director meeting, but also it shows the other party that you're thinking ahead. You're looking about where you're looking at where, might this go? And if you're proposing a meeting to discuss, think about who you would like from both sides to attend. So, if you wish a director to attend or someone from the other side who is, higher level than your normal people, put it in that letter. And as it says there, consider badging it as a pre-action protocol letter. Settlement meetings, pretty much exactly the same here. Review your strategy, review your letter of claim, and that's another reason why it's quite nice to have it, because it's the summary and the detail that you need as a reminder. And also think about the other party's arguments. Get ready to deal with them. Don't just ignore them. Always have an agenda for a settlement meeting, because there will be things you will want to talk about, and having the agenda, sharing it before the meeting, sets expectations. Deal with the logistics, where it's going to be, who's going to be attending in particular. Take notes and issue the minutes of meeting afterwards. Stay calm, and also really important, ask questions. We really get into the habit of, pushing our position, but quite often it's good to ask the other party, what quality of work did they expect to provide? On what basis do they not think it's a variation? In what respect, did the claim come as a surprise to them? All sorts of things can be dealt with better as a question than, just putting forward your case. So just to summarize, be commercial, follow your contract, know what your contract provisions are, know what your timescales are, keep those records through the project, keep the records, and make sure any agreements are documented in writing. A lot of this is just about organisation. It's not exciting stuff, but if you can do everything that I've been talking about today, then it puts you in really good stead to get a good resolution. And if you can't do that, it puts you in good stead to have a successful adjudication. So hopefully that's been useful. We've got my contact details there if you've got any questions that you'd like to raise.